The Wisconsin Supreme Court today upheld 3 laws, 2 of which were defended by the State Department of Justice. Attorney General J.B. Van Hollen, thanks for a quick update on those. Thank you very much.
Happy to do it.
Premier ruling today, most important, Act 10. Why?
Well, Act 10 is a big ruling, as are, I think, the other 2 rulings as well, because all of them upheld the will of the legislature. When we talk about what democracy looks like, it's all about, in our society, people electing legislators and a governor to pass laws that implement policy they believe in. And unless there's a clear violation of the Constitution, those laws should be upheld. And even though there may be disagreement as to what a clear violation of the Constitution was, in all 3 cases today, the courts deferred to the legislature, which is a very important win for democracy. It's a very important win for the will of the people.
Well, let's talk about issues in the Act 10 ruling. Mayor Soglin said it violated in a statement, said it violates the home rule clause. Obviously, the court disagreed. How important is that issue, General?
Well, I think it's real important. I think that in all of the litigation about Act 10, that the constitutional case law, both at the state and federal level, were very clear. Whether it be the issue of freedom of association, whether it be the issue of home rule, or the issue of contracts. In every single case, I believe that we were very, very strong. Of course, it's always hard when you're forced to defend from many different directions, but we did so, and we did so successfully, because I think contrary to what some litigants on the other side may have said, hoping that they'd have a victory at least at one level, and that would be a victory, they had a victory on none. The rule of law was upheld in the Act 10 case by a 5-2 majority on every single issue, and I think that's very important.
The way you opened your Supreme Court argument, you stood up and said there is no constitutional right to collectively bargain. Is that the biggest takeaway from today's decision, sir?
No, I don't think so, because I think everybody really agreed on that. The reason why I brought it up is because the litigants on the other side very quietly agreed there's no constitutional right to collective bargaining, because there's case law from the Supreme Court that clearly says that. But then they really turned their argument around and argued that there were other fundamental rights being violated that essentially amounted to the same thing. And I wanted the court to understand that we're talking about a constitutional right to collective bargaining no matter what issue they frame it in. I think what's really important here is that there are a number of aspects to look at. When you talk about home rule, it's that we had a significant statewide issue that was being addressed. What the governor was trying to accomplish and what the legislature were trying to accomplish really did impact the good and policy for the whole state. And you can't just pick out certain areas of the state, especially major municipalities, and say that that doesn't impact what happens in the rest of the state. So that's perhaps a bigger takeaway than anything.
Well, Act 10 now has also survived challenge in federal court. So this is the final word today on it?
I think it should be. There's still a couple of outliers we have out there, a couple of things to be decided on 2 other cases. I think they're relatively inconsequential based upon this ruling and all the rulings we've had thus far. I really do believe this is the last word.
One more question on Act 10. In 2011, the court ruled basically that the Senate and the Assembly can make up their own rules. That was also a critical ruling, wasn't it, sir?
It was some time ago, and people tended to forget about that. The reality is that what happened in Act 10 was unusual. The fallout of the Act 10 legislation or the proposal of it was unusual. And so it led to not just constitutional questions as to the content of Act 10, but procedural questions as to how it was implemented. We were victorious in all of those issues.
Okay, let's move on to the photo ID ruling. It's not as clear because of the pending federal actions, right? But can you basically summarize what the court held today in terms of our law?
Yeah, once again, they found that it's constitutional. And I think people thought perhaps the issues under our state constitution were more of a question than the issues raised under the federal constitution. Unlike Act 10, where I think I can comfortably say that the lawsuits were mostly, if not entirely, frivolous, the voter ID lawsuits weren't. I mean, these are cases of first impression, cases that really legitimately needed to be decided by the court, but we've had huge victories, and victories by a significant margin again, 5-2 and 4-3 in our state Supreme Court, upholding our voter ID. I think those do 2 things. They go a long ways towards influencing the federal decision, and voter ID, similar to ours, has been upheld by the United States Supreme Court, but also goes a long ways towards helping us to get the will of the people, meaning the law, in place, hopefully by this fall, because the injunctions, of course, no longer exist in the state court cases since they're resolved, and we can focus on getting the injunction at the federal level stayed.
But how do you reconcile today's Supreme Court decision with Judge Adelman basically saying, this law is so broken you can't even fix it?
I don't believe you can reconcile it. And when Judge Adelman came out with his ruling, I think I was quite clear in stating that it was not a very good ruling, that it was not steeped in the law, and that it was grossly overbroad. And so hopefully we're going to get a chance, obviously we're going to get a chance to appeal that ruling, but hopefully in the meantime that ruling doesn't stand in the way of the will of the people in having photo ID this fall.
Is there any chance of a speedy ruling on this so it would photo sir?
I don't anticipate a speedy enough ruling on the merits of the case, but I anticipate we can get a speedy enough ruling on whether the law should be enjoined for our fall election or not.
Can you explain DOJ's position not to defend the domestic partnership law?
Yeah, and it was really ultimately my decision. As an officer of the court, I really had to weigh two things. I had to weigh two different laws. I had to weigh a law of the legislature and our Constitution. And seldom do they really come into direct conflict. In this case, I thought there was a very direct conflict, and my obligation was to defend the Constitution first. And whereas I say the will of the legislature, unless it's clearly a violation of the Constitution, should be upheld by the courts, in this case, I believe there was a clear violation of our Constitution. As an officer of the court, I could not in good faith defend that law. The Supreme Court disagreed with me. There was discussion within the case that had it just been a discussion of, is this a violation of the Constitution, the decision may have been different. But it was more of a discussion is this a clear and blatant violation? And that giving all due deference to the legislature, as I think is very important, and making sure that if they can find it constitutional by any grounds, they should do so. Under that determination, they found it to be a constitutional law. I certainly don't fault them for that. I simply disagree with the analysis.
What's the interaction between today's ruling on partnerships and Judge Crabb's ruling, and your fighting that?
I think there's very little interaction. I think that perhaps Judge Crabb's ruling and rulings similar to that have happened throughout the country, and the kind of the change from what I understand in the public mindset about same-sex unions and same-sex marriage, that certainly could have had an impact on what the court thought of this particular case and how landmark this decision was really going to be anymore, or really whether it was even moot. But I don't think that this decision is really going to have an impact on the federal cases at all.
Do you expect the U.S. Supreme Court to take the Wisconsin law and the Indiana law, and that be the one that will decide this issue? You know,
I don't know. I think just within the last few weeks alone, we've had a couple of federal circuits who have made decisions on cases on the issue of same-sex marriage. Depending upon how rapidly a decision comes out of the Seventh Circuit Court of Appeals, I think is going to dictate whether they take all these cases at the same time or whether they pick and choose one over the other. Certainly Wisconsin and Indiana, from a chronological standpoint, were behind some of the other circuits, but the fact that they've put it on the fast track is helping us to catch up. And if the case is resolved before they select cases, the Supreme Court, for their next docket, I think there's a real chance that Wisconsin gets in front of the United States Supreme Court.
What role, if any, do your personal beliefs play in your decisions to not represent the partnership law?
You know, none, and they never have in any of the decisions. As a matter of fact, specifically with regards to the civil unions legislation, I perhaps toiled over that decision more than anything I've done in my entire career, for fear, in part, that people would say it's my personal decisions that would interfere. But ultimately, I had to make a decision based upon, as an officer of the court and the state of the law, what I needed to do, regardless of what I thought some of the media repercussions would be. And those are some of the hard things to do. Of course, had I defended the law, nobody would be asking me these questions today. But had I defended the law, I would have, for the rest of my life, thought I did something that was legally wrong and ethically wrong. And that is certainly far more important to me and my honor.
It's a campaign issue now. Those that want to replace you are debating whether they should be able to pick and choose which laws, which constitutional amendments to bring the full power of DOJ to defend. What's your advice to whoever occupies this office next on that issue, General?
Well, I think they have to focus on two things: the rule of law and ethics. Obviously, it's their obligation to uphold the rule of law. The rule of law is not only statutory law and case law, but constitutional law. And they have to recognize which laws are more important. They have to then look at whether there is any colorable argument to defend their case. And I would submit, and in my case, in every case except one, in 7.5 years, I believe there was a colorable argument. I have defended many cases, which ones they are I won't name, that I didn't believe, from a public policy or personal standpoint, I didn't believe were what should be the law. We defended them anyway. We defended most of them very successfully, and it was our obligation to do so. And I think that that is always going to be the default. When people such as General Holder are telling AGs, which is none of his business to tell us what to do in the first place, that we shouldn't be defending marriage laws, that's a horrible mistake, because I think each AG has to look at their specific law, whether it's in their constitution, what the law says, and whether they believe there's a good faith argument, and make that decision.
You mentioned the U.S., Mr. Holder. He filed yesterday in the photo ID, right? Do you have any reaction to U.S. DOJ's filing?
Yeah, he really offered nothing new of substance. And, you know, once again, it's him weighing in on state legislation. And I think our court today has been very clear that state legislation deserves deference. It certainly deserves deference from the Federal Department of Justice as well. He's got many things that really are in his wheelhouse that he should be working on, and this sort of grandstanding, I think, is unfortunate. But when you look at the merits of what he filed, he has really offered nothing new, and so I think it'll kind of be a non-issue during this case.
Then final question, these three cases, Act 10, photo ID, domestic partnerships, what's your estimate of what they have cost Wisconsin taxpayers, General?
Oh boy, I haven't given any thought to it.
Certainly millions?
Yeah.
More than 10 million? I'm sorry to interrupt you.
You know, obviously there is a cost. There is a cost associated. There's a non-dollar cost. There's a non-dollar cost with regards to, you know, election integrity. There's a dollar cost with regards to if Act 10 is fully implemented everywhere, how much does that save the taxpayers? So there are a number of costs that aren't going to be crunched. But if you're talking about just legal defense, as I've said in many cases, you know, one of the nice things, I guess, about being a government attorney is we don't keep hour sheets or time sheets. So we can't go back and recreate what the actual cost was in attorney time. But it certainly, these cases certainly took a lot of attorney time.
And this one really is my final question. Why is it that all these major laws now have to be resolved in the courts? That always hasn't been the case, has it, sir?
You know, it hasn't, and I think you know this well. It's been a bone that I've had to pick. You know, it used to be, an analogy I like to give is you used to watch TV, and when you were a kid, and you learned how a bill became a law. I'm just a bill, a lonely old bill, and you learned that they became a law because they got passed by both houses of the legislature and signed by the governor.
And it stopped there.
And it stopped there.
Usually.
Well, nowadays, almost any landmark legislation that's come out of Wisconsin has also then had to be defended through district court, appellate court, and the Supreme Court, and multiple times. Passing significant legislation is much more difficult because of the litigious nature of its opponents nowadays. And I have nothing against people using the court of law to resolve differences, but there has to come a point where unless there's a legitimate, non-frivolous legal argument that can be brought, that we need to let our policymakers do their jobs and let our courts focus on doing theirs.
Attorney General J.B. Van Hollen, thanks for your time.
Thank you.
Thank you.